Hi guys, my name is Yusuf Oluwafemi Salako, popularly known as Ori David, a 500 level law student of the University of Lagos and founder of the Ori David Consult. If you are new here, I say welcome to you, and do not forget to click on the subscribe button down below so you get notified whenever we put up new videos. So our topic for today is a very interesting one, a very relatable one. In fact, I can boldly say that this topic is one that basically reflects our everyday activity. This topic we are about to discuss, we are all liable. Yes, you and I are all liable, especially in this country. This topic we want to talk about today is none other than torts as a form of trespass to person. So when we speak of trespass to person, it is a tort, and this tort is one that involves direct interference with a person's body or liberty. So trespass to person is a direct interference with the person's body or liberty, and this is why there are three main forms, namely assault, battery, and false imprisonment. So assault and battery relates to that interference with the person's body, while false imprisonment relates to that of the person's interference with the person's liberty. Now, there is a common element that runs like a thread through these three forms, and that is that these torts can only be committed by direct means. So the question is, also direct means. What does it really mean in the context of trespass to person? So supposing I throw a log into the highway and it hits a person and it's a passerby, that will be direct, right? Because yes, I threw the log and it hits the person. So if the person had knowledge, that person would have apprehended a reasonable apprehension of what? Fear. That could amount to assault. And if the log should hit the person, there is contact, so that would amount to battery. And then there is a direct interference between my action and the person's between my action and also the person's body. Now take another example. Supposing what I do is that I threw a log on the highway, and then you stumble on it. If you stumble on that log, that will be indirect. Yes, there is no direct interference between my action and the wrong that you have suffered. So you must understand that in trespass to person, there must be that direct interference. Now, the notion of directness is always very easy to understand when it comes to battery, but somewhat problematic when it comes to assault. For false imprisonment, yes, where there is a physical restraint, yes, the notion of directness is also easily understood in that regard. Now I must also state that trespass to person also says that it is an intentional tort, and that is where you hear what the court said in Letang versus Cooper, that where there is no intention, do not bring an action under trespass to person, rather bring it under negligence. So supposing I hit someone but I didn't have the intention, but then I should have actually been careful. You cannot bring an action under trespass to person. Like you cannot say it is battery. No, because of lack of intention. Trespass to person is an intentional thought. So when we talk about trespass to person, no, it's an intentional thought. Where there is no intention, then you bring the action under negligence. Now, when we speak about assault as a form of trespass to person, it's basically any act of the defender that causes the claimant's reasonable apprehension of the infliction of battery. That is, any action of the defendant that gets you scared. Any action of the defendant that made you fret reasonably, then it is an assault. Simple act of assault when you throw water at a person. It is an assault when you throw water at a person. And if any drops should fall on that person, that will be a battery. But that is on the presumption that you had knowledge that water was about to be thrown on you. And you can see the case of Purcell and Horn Also, another simple act of assault is to when you spit at a person, it is an assault. Also, when you ride a horse at a person and you charge at the person as if you were going to collide with the person, as long as the person has knowledge of that, that would also amount to an assault. Now, assault requires no contact. Yes, it requires no contact because in essence is conduct that may actually lead the claimant to apprehend the application of force. The law of assault is simply to ensure that you have a stable state of mind, that you do not live in fear. The law of assault is to ensure that the people do not have reasons to fret. So even when you have not really caused any form of physical damage, the fact that you have messed with my internal state of mind, and you have done so in a way that every reasonable person would actually have their minds messed up, that is automatically an assault. Now, when we use the word apprehend in assault, it basically means, in the sense of expect. Now, what are those elements you must prove when you want to prove this assault? First is that you must show that there was a threat to apply force. You can see the case of Stephen versus Myers, and also that there is reasonable apprehension of fear. You must also understand that words alone may constitute an assault. See the case of R versus Island. As well, words may also negate assault. You can see the case of Tuberville versus Savage. Another thing you need to understand is that where the words that you have used are clearly intended as a joke and were also taken as such, it cannot be assault. So if I should say something and all I was just doing was just joking around with you, and you were aware I said I was going to hit you, said I was going to beat the shit out of you, but you are aware that I was just joking, that cannot amount to an assault. You can see what happened in the case of Chambers versus DPP, a very funny case. In Chambers and DPP, the defendant, he took to Twitter, okay? He took to Twitter to threaten to blow up an airport after a delayed flight. It was clear to all that, taken in context, he was joking. And the court said that those words cannot constitute an assault. I think there was also a situation at the point where somebody, was he also on this Twitter? Someone was also threatening to blow up the Oyinbo branch of UBA or thereabout. That was clearly intended to be a joke. Such cannot be taken as an assault. Now we have come to the end of today's class on assault as a form of, or as a tort of trespass to person. Now, I need to also state it clearly that what we have done today is an abridged version. What we have done is just to look at what assault means superficially. So if you want a detailed exposition on this particular topic, all you have to do is to join our online tutorial, which goes for 3K per month. You will see details in the description down below. Join our online tutorial, the Ori David Consult online tutorial, 3K per month, and you can have detailed expositions as well as materials and attention as far as any topic in law and English language is concerned. Join, and also you can be a member of our WhatsApp TV, that is the Law, the Street, and the Crossroad WhatsApp TV. Here we also discuss different topics in different spheres of law, as well as also look into raging debates and legal issues and other things that relate to law and language. You can also join, that is also free. But do not forget, join our online tutorial if you want to know more. And all these cases we have mentioned, they are here. We have case reviews for them. You can also be a part of those who would enjoy these benefits simply by paying 3K monthly. 3K monthly means that you are simply paying 100 naira every day. Therefore, join the Ori David Consult online tutorial. Till I see you next time, do not forget, my name is Yusuf Oluwafemi Salako, popularly known as Ori David. Do not forget to always stay jiggy and do not allow anybody to put your mind in a restless and restive position. No matter what they do, don't fret.
Badu, Badu,